Yeah. Where's my bit? Isn't there seven amendments? Honorable Senators, let's just make sure that everyone is in possession of the amendments. There are two lists of amendments. There is a list as circulated by the Honorable Attorney General, and there is a list as circulated by Senator Hussain. Yes? Yes? Okay, okay.
Yes, Madam.
Clauses 1 to 3.
The question is that clauses 1 to 3 stand part of the bill. The question is that clauses 1 to 3 now stand part of the bill. Those in favor say aye.
Aye.
Those against say no. The ayes have it. Clauses 1 to 3 now stand part of the bill.
Clause 4.
The question is that clause 4 stand part of the bill. There is a proposed amendment circulated by Senator Hussain. Senator Hussain.
Thank you very much, Madam Chair. Madam Chair, the essence of this amendment to Clause 4 is an amendment to Section 4 of the Parent Act. And during the debate, we would have raised several issues with respect to the way in which this particular provision was drafted, in that it removes any discretion of the court to determine whether or not a matter will remain under the old system or be transferred under the new system. This being the transitional provision of the legislation. So, Madam President, we propose to make an amendment so that the accused or the prosecution is required to make an application in writing to the magistrate, so that the power of the magistrate is preserved in making the decision. So that's the essence of the first amendment. The second amendment is that we delete the word or and insert the word and, where we have, if the prosecution makes an election in the joint trial issues. If the prosecution elects, we want also that the accused must consent to that position in joint trials, and with respect to joint charges, it's the same position, where if the prosecution makes an election, the accused must consent to the matter being transferred under the new system. And those are the essence of the amendment, please, Madam President.
Attorney General.
Thank you, Madam President. I thank Senator Hussain for the proposed amendments. I've had a chance to look at it. They are of two different types, so perhaps I can address them separately. The first one is may elect to have the case and substitute the following words: shall make an application in writing to the magistrate to have the proceedings.
Yes.
I understand the root of what you're getting to, which is to formalize the manner in which this happens. But I asked if you can reflect upon the language of subclause 2 as we propose it is amended. It is upon the election that 32A kicks in. So where there is an election by either party, if that is the case and the magistrate is told so, then 32A kicks in. And then 32A provides for a prescriptive route as to how the person is to be brought before the court. The essence of 32A is really to make sure that upon election, the magistrate shall order the accused to be brought to court before the master, and then you deal with him in accordance with Part 2. So we felt, and this language actually came squarely from Mrs. Elder, who recommended the cleaving out of the process of a new 32A and routing it into a springboard which Section 4 had set up. So we felt quite comfortable that there was a process. In fact, the process went further to something which we had omitted, because in the successive views of this bill, we had not thought about how someone who was in an existing proceeding came back before the magistrate. So what we said is, upon election, magistrate says, bring you back before the court immediately, take you before the master, and then go through the root process of Part 2. So with respect to the proposed amendments, for the first part of Clause 4 that you have suggested, I respectfully decline the invitation to treat with it this way. I understand the mischief that you're attempting to get to. I think it's covered by the reference to 32A and to Part 2. The second part of the submission is effectively that you have to have consent. And this is to put in a third leg. The circumstances that we've put it for subsection 3A, 3A is where subsection 2, that is you, either party can elect, shall not apply in the case of a joint trial unless prosecutor elects in respect of all the accused or accused, all the accused elect. We didn't want to have a position of having either of them consent, nor did we want to involve the court to consent whether that should happen or not. And if I could explain why. We didn't want to have a review argument on what the court should or should not have done. If we look at the society's perception of what abuse looks like, not that it is, because legal rights certainly aren't abuse. If you look at the manner in which judicial review has interrupted magisterial proceedings, you can tend to have trials stretched for 10, 15, 18 years in preliminary inquiries, because you're literally reviewing every aspect of the case. So removing the issue of consent was one of the things to get there. And on the back of Hilroy Humphrey, we stayed with the fact that it is a process to be elected. A fair trial can happen in both routes. And for that reason, we didn't need to put the court through an exercise of having to consider whether it is appropriate or not, because either party says the manner in which they wish to have their trial managed. So for those reasons, we are slow to take this introduction of the concept of consent. This is something that we had a lot of debate over, a lot. If we introduce the consent of the court, then we're looking at the appeal factors, we're looking at judicial review, and if you look at some of the leading cases that are stuck in 15, 20-year cycles of preliminary inquiries, we want to avoid that. We just want to get on with the trial.
Madam, may I?
Yes.
AG, with respect to the first point that I'm going back to the section that deals with including the application before the magistrate. Now, I understand what you're saying with respect to the application of 32A, but at the end of the day, once the prosecution says case X goes to the master, then the court has no discretion.
Correct.
Because 32A speaks of immediately going to
That's
Part
correct.
2.
Yep.
And that is the issue I'm having, is that we need to have some sort of safeguard, because there may be some prosecutions in which the prosecution can in fact manipulate the process. And that is what I'm trying to avoid, giving the court that ultimate discretion to determine whether or not it's fair for the accused person to have gone through, let's just say, 4 years of a PI, and then as soon as the PI is about to be completed, or you realize that the prosecution case isn't going the way that it should, that they just they decide to go to the new system. So it's really a matter of procedural fairness I'm trying to protect. I understand Hilroy Humphreys, the PI. I know that will be an argument that will come. But
Well, my argument is a little bit broader than that, but please continue.
But the thing is that we need to create that protection. With respect to the other amendment, and just short response, is that if we use the word consent, that the accused person consents to the fact that the consent to the election of the prosecution for the joint trials or the joint charges. It doesn't have, it's a straightforward thing, is whether or not the accused person consents or not. So I'm slow to accept the argument that it will increase the JR applications.
What happens if the accused says no?
If he says no, well, then you proceed under the old system for joint charges, joint trials. And I think that is something that they have a legitimate expectation of from the date in which they were charged until they're committed or if they're discharged. In whatever
All of these
instance.
arguments found themselves in Hilroy Humphrey. Every single point that you have just raised was in Hilroy Humphrey. Legitimate expectation, the manner in which they should go, the need for consent, it fell into the right of fair hearing, it fell into due process, and the Privy Council decided all of that. But in terms of an abuse point, the prosecution abusing the process, there is still the opportunity to seek to have the case discharged entirely. And that is always preserved in the body of the trial. So this argument has been ventilated quite properly for many, many years.
But
There will be the prosecutor's point of view, and there will be the defense attorney's point of view.
But the point on abuse, you would understand the difficulty in someone succeeding on an application for abuse of process to quash an indictment. It's it's a very high threshold that an accused person has to satisfy.
Senator Choate?
Thank you, Madam Chairman. Honorable Attorney General, I was thinking that the difficulty perceived by Senator Hussain may not necessarily be one that is incurable, because the magistrate may not have oversight, but quite frankly, I don't see anything which prevents someone in that situation from judicially reviewing the decision of the director. I could be wrong, but it seems to me as though that may be an option available to someone found in that situation. What I don't follow, though, and I'll be grateful if you could explain it, is why are we treating accused persons who are jointly tried or jointly charged, I beg your pardon, differently from persons who are charged singly? And I ask this because in your closing on the last occasion, you referred to the contribution sent to you by Mrs. Elder, and you referred to the 2011 contribution, which was sent via the Criminal Bar Association. I have looked at that, and I am not seeing anything referring to the differentiation. So I don't know if this is something new, but certainly having the tremendous respect that I do for Mrs. Elder, if there is something that you have that you could perhaps circulate to us to explain why that distinction is acceptable, I will be most grateful.
Sure. She did write to me and did find a copy of her letter to Ms. Chrislyn Moore as well. I do have that. The argument put forward by her effectively is that the lacuna exists in that we had not treated with joint trials and joint accused, and that there could be a battle amongst accused as to which is the appropriate process. And then from a policy decision, we had to consider, well, do we want to have a battle of purposes? Because I do follow your argument. Look, if I, the individual, want to go and get my trial done, why should I be chained up to the fact that 4 other fellows want to stay in this preliminary inquiry? I understand that. But then the argument as to whether the resources of the state are being best managed also feeds into that, because then we're splitting the resources in 2 different domains. Then we get into what about the inconsistencies if there is a determination in the magistracy as to, for instance, a no case submission which succeeds, there's not a prima facie case, whereas you're at the High Court in a different point, and then inviting for a judicial review of the circumstances because X is now in position of no prima facie case and Y is before the indictable court. There are too many permutations and combinations around it.
I know, and actually I was looking at it from a prosecutor's point of view, because I was thinking of the kind of situation where you have several joint accused, and there is one who has the potential of possibly turning state witness, as we say. And if that person doesn't have all his other fellow accused agreeing with him.
Yeah.
The prosecutor may not know what's going on in the head of the accused. It may only be his counsel. But if we insist that all of the accused persons have to agree, then we may miss an opportunity
Yeah.
there to actually have the matter expedited and have the prosecution's case fortified. So I don't know if that has been.
It's a brilliant case example. Forgive me, Madam President, may I? It's a brilliant case example which actually finds its remedy in a different law, in the plea bargaining law, because it is in the conduct of that plea arrangement, plea discussion, and plea hearing that we can cleave the accused. So state witnesses, as happened, as I shouldn't go into it unnecessarily, but the bottom line is we can treat with it under the plea bargaining legislation and cut the pack.
Honorable Attorney General, I don't want to press a point, but I think the reality of this situation has to be taken into account. We have 6 men charged with murder in the same remand yard, possibly in the same cell, right?
Yeah.
One has it in his head that he could possibly, or he might be the weak link, and he could possibly turn state witness. He certainly, because he wants to save his life, may not want to engage the plea bargaining process at that stage. So that really is of no use to him, especially when sometimes you have to conduct, even though it's improper, you have to conduct your client conferences in the hearing of a prison officer. So I am just wondering whether there could be some further consideration of this, or we could have something to say, allow for an exceptional case, let's say, so that possibility will remain.
Yeah.
I don't know if that would be considered at all.
May I? Senator Choate, I think with the years of experience and the perspective that you bring to this discussion, one would have to be entirely foolish not to hear what you're saying and to not take very good caution about it. I think you're 100% right. Question is a matter of timing. So we've debated this particular point from a policy perspective with the judiciary, with some of the other practitioners, with the DPP's office. And the process that has come back to us is, let's see where the system falls. Let's see what the numbers look like. How much injustice are we going to have in this particular arrangement? Without calling a name of a case, there is an actual case right now with multiple accused for murder, one of whom is now on the state's wagon. And
Attorney General, I know you're not even giving a name or anything, but I think we should not discuss any case that is before the court, any criminal matters at all. So maybe you can present more hypothetically.
well, I was stopping right there. I join you in the sensitivity, Madam Chair, and I'm, of course, guided by you. So in that particular construct, the simple point is that there are other remedies to treat with it. I think that the process will probably involve the Parliament having to reconvene once we get some rhythm and cadence on this issue. And it may very well be apparent then that, look, we can get more efficiency by allowing for the cutting from the pack. I'm also very minded to settle this issue of judicial review and DPP's powers from just a point of view. In fact, I'm contemplating right now a case stated from the Attorney General as opposed to an appeal, because I think that the law needs to be clarified on that point. So I'm contemplating an AG's reference as we speak. I've been working on it for the last couple of days to think of how we can settle the law on that point. So I hear you loud and clear. I think the caution is welcomed. Of course, Senator Hussain, I agree, has hit upon the issue as well. From a policy point, I'm not equipped at this point to make a decision left or right. The position having come at me that if I don't treat with it, I may invite chaos into the issue, I propose that we allow it to settle in, and we will continue to take a careful look. Once we get the case stated or appeal positions back on the JRing aspects, I think we're going to be a lot clearer on this particular aspect of the law.
Senator Sobers.
Thank you, Madam Chair. Honorable Attorney General, with respect to Senator Hussain's point, possibly contemplating an issue of an abuse of process by the prosecutor, could we not make the election process itself time sensitive, subsequent to the legislation coming into force? Because it would curtail the ability of a prosecutor or an accused stretching the matter along for an elongated or protracted period of time and then triggering the election process only to serve his or her benefit.
Very sensible recommendation. Option 1, we allow the criminal proceedings rules to prescribe the time frames by which things ought to be done. And then we amplify the application of what is right now an unknown aspect. What are the sanctions to failure? That's a big issue in the criminal proceedings rules right now. Canada has actually applied very heavy judicial sanctions, and other jurisdictions are flirting with it. So I think it's a welcome thought, but we're at the beginning of this in our country. And I'd like to allow the system to go into effect. Something that I've come to appreciate pretty well now sitting on this side temporarily, as we all do in the various positions that we sit. The equality of arms appears to be largely in favor of the state, because one thinks that the state can exercise certain functions. The truth is that a nimble, sharp attorney can take proper advantage of the state, because the state is very constrained in terms of resource utilization and allocation, and therefore finds itself on the back end of having matters just disappear because of a lack of capacity. So I would be cautious not to put into parent law statutory time frames which could inevitably see the baby thrown out with the bathwater just yet. We have, over the course of time, been tightening time frames in pieces of law as we've come to treat with them. But I don't respectfully think that now is the opportunity, as we start to put in these things, as welcomed and as sensible as they are. I think we need to see the system in operation and allow the rules, the criminal proceedings rules, to lend us some assistance.
Senator Vera, and then Senator Mark, and then we'll have to resolve this issue. Yeah.
And on that point, I just wanted to say, we can't legislate for everything. I think in a lot of the legislation that we're going to be working on with the criminal justice system, there must be room for the judiciary to do its own guidelines, just as how you had the judges' rules, and they will set their own timeframes on what they regard as best practices. We can't do everything for them.
Senator Mark?
Madam Chair, I wanted to ask the Attorney General whether it is his intention to have this legislation reviewed within a specific time frame, having regard to what you have just said earlier. You have taken on board the points made by Senator Choughton, my colleague, but does that mean to say that you are thinking about reviewing the legislation within a specific time frame?
Madam Chair? Yes. Thanks, Senator Vera, for echoing what I believe is some of the sentiment put forward. Let me make it clear to both Senator Sobers and Senator Haynes. I hear you loud and clear. There is merit in this suggestion. Senator Choughton certainly very clearly put forward the same point. I'm just speaking about the timing of it. I don't think we're ready for that just yet. But it now feeds into Senator Mark's inquiry as to whether we intend to review. The answer is yes. And I'll draw you to the example of how, as a government, we've done it. If you look to the first opportunity that we had in doing the family and children division, we actually caused 19 laws to be amended in the 5th schedule to that particular act. We have since come back to Parliament 4 times to amend those laws. And in fact, we're going to do it again today when we go to the next bill, the next debate, and we're going to do it on Friday and Monday again. So we've been keeping these things under a very tight management and under careful watch. And our attitude is quite simply, the Parliament is here to deal with the law. So we have this under a constant review position. We've established working groups where we've blended law reform together with law revision and AG's working team secretariat with the stakeholders. So we do have it under constant review.
Madam Chair, AG, would you be inclined to consider an amendment to insert in the legislation that within a period of 2 years, this bill, when it becomes an act, would be subject to review by the Parliament? And if something comes up before that period, as you have said, then you take the initiative. But at least the Parliament would have in the law a process for review within a time frame. Would you have any?
So that's not uncommon. The Dangerous Drugs Act has that very provision that Parliament shall every 5 years review the law. You know how many times that happened? 0. Secondly, they also mandated the establishment of a joint select committee to do certain work, which has never happened either. What we saw bring incredible result recently is the use of our joint select committees. Senator Choate as chairman of the committee that she sits on, you, Senator Mark, as chairman of the committees that you sit on. We are now, Senator Vera, Senator Richards, many of you have had the experience of activating your joint select committees and causing results. And I think if we were to allow that route to prosper a little bit, that we can actually find ourselves improving laws as we go along. Certainly I've paid very close attention to the work that concerns me the most in the joint select committees. I've purposefully removed myself by way of recommendation to the Prime Minister from the Joint Select Committee on National Security and also from the ability to sit on that committee which Senator Choate manages, because I consider it infra dig for the Attorney General to be a member of that committee. I ought to be brought before the committee. In fact, I regret that I am not personally brought there. The technocrats come as opposed to the functionary. For some odd reason, I don't see why I can't be interviewed by a committee. So I think it's a useful purpose. I think we ought to take it on the different end, at least for now, as our parliamentary structure improves.
Senator Thompson-Aye.
Yes. The Jamaica, as I mentioned before, Jamaica Act has a provision, the Committal Proceedings Act, which gives to the accused the power to make a submission that the evidence is insufficient. The Jamaica law, the bill, it went into a joint select committee. A number of people worked on perfecting the law. And together with all of that, there was an undertaking, or it perhaps may be written in, that within 3 years, they are going to review the legislation. So it doesn't mean you either go to Joint Select Committee, which is your recommendation, or you review, because both of them happened in the Jamaica situation.
Attorney General, and after the Attorney General speaks, I will be putting the question to the vote.
Senator Thompson-Aye is very correct. But as I've said on many occasions, our constitution is unique in the CARICOM context. We are the only constitution, our 1976 constitution, that does not have the exception for national security purposes. In other words, other jurisdictions do not wrestle with the passage of laws the way we do. We are very often faced with 3/5 majority laws that just can't pass. And being subjected to the type of interrogation that I am in the current capacity that I sit, I can tell you that that's not a pretty picture. So our constitution is very unique, unfortunately so in some instances. And for that reason, those types of review arrangements, etc., don't prosper in our context.
Honourable Senators, the question is that Clause 4 be amended as circulated on behalf of Senator Hussain. Those in favour say aye. Aye. Those against say no.
No.
I think the noes have it. Honourable Senators, the question is that Clause 4 now stand part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it. Clause 4 now stands part of the bill.
Clause 5.
The question is that Clause 5 stand part of the bill. Attorney General, you have circulated amendments.
Yes, Madam Chair. You ready?
Yes.
May I?
Yes.
Thank you. Madam Chair, Senator Sobers made a very important observation with respect to subclause 3D. If we look to Clause 5 of the bill and we look to 3D, you'll see that we're treating without limiting the generality of subsection 2, the DPP may prefer and file an indictment under subsection 2. When we get to subclause D says where a magistrate was unable to complete a preliminary inquiry before the coming into force of this act, or a master is unable to complete a sufficiency hearing because of these reasons, and evidence filed before the master discloses in the opinion of the DPP, that would have been too restrictive. And therefore, we propose that we delete the words, the evidence filed before the master discloses. That's in the choiseul of subparagraph D. So you will delete the evidence filed before the master discloses and put there is in the opinion of the DPP. That ought to take care of the restrictions that reference to master only would have caused. In subclause 3E, Senator Choate raised a very important point as to how we treat with child witnesses and versus child accused, because you can have serious circumstances of child accused. Senator Choate raised another very important point, which was the child committing an offense as a child, spending time in a child rehabilitation center and arriving before the court as a grown individual. It's actually something that we see every day. It was for that reason that we actually introduced the judge-only trials, specifically with that in mind. In what was then YTC, now is a CRC, I spent a significant amount of time engaging with the inmates there, and the one group of individuals who said they would happily take a judge-only trial were the people in the CRCs, because they said they were all mortified of attending before a jury as a grown adult who had committed an offense as a child. So I wrestled with how to treat with the observation that Senator Choate made in how we treated with child appearances, child accused before the process of trial. I, in thinking about it, perhaps reflected that the best way is before the judge-only route, if that's the case, but it's somewhat assisted by the fact that we now have whether the child is going to be treated as an adult or a child at the trial, and whether we go before the children's court. You'll recall we gave an undertaking to come back to the issue of the in-betweeners, those who aged out at the CRCs, where we were going to house them and how we were going to treat them in the judicial process. We're nearly finished with that form of consultation. Some of it is actually done by the team that will be next on deck with us in the next motion that we do this afternoon. So I couldn't treat with that limb, Senator Choate, just yet, but it's active in my mind. What I thought was possible was to introduce the concept of the child witness alongside the child accused. So we propose, Madam Chair, in subclause 3E, that we delete the words child witness or adult witness who has been assessed as one subject to threats, intimidation, or elimination, and we substitute the words child accused or child witness or an adult witness who has been subject to domestic violence, threats, intimidation, or elimination. If I could just close by saying, when you look to Chapter 1201, and you look in particular to Section 23(8)(e), the wording in the law as it stands right now says, and these are the only words that are different, in exceptional circumstances. That's not in our draft. To deal with offenses of a violent or sexual nature, and where there is a child witness or an adult witness who has been assessed as one subject to threats, intimidation, or elimination. Now, the question obviously arises whether we should deal with other broader concepts like inducement, like other aspects. And whilst that is appealing to me intellectually, two things jump out in terms of treating with it that way. Number one, this law can potentially treat with matters which are underway already pursuant to Section 4. Number two, the practice as it has grown up is one where the DPP exercises the discretion to treat with matters in the circumstances that he has in dealing with this law since 1961 in these exceptional circumstances. I'm loath at this juncture in introducing new law to change the practice on the DPP just yet, because I don't have the reference points to make that decision. So in the circumstances, we propose the simplest of the amendments, which is to introduce the child accused as well, to capture the submission that Senator Choate very commendably made to the Senate. And those are the reasons in the round, Madam Chair, for the proposed amendments by the government.
Senator Vera.
And thank you, AG, for bringing up the point about inducement, which I raised during the recess. I agree with the amendment that has been circulated, but I do want to put on the record, my understanding is that this whole Section 5 is to prevent obstructions of justice, perversions of justice, by giving the DPP this fallback position. And where we are looking at E, we are talking about a child witness or a child accused has been the subject of domestic violence, threats, intimidation, or elimination. Now, of course, we're talking about building a protective environment for children. And it seems to me that a lot of times in our society, justice is perverted because of this very thing about inducement or alienation, beseeching. Oh, don't go and give evidence because you're going to put your stepfather in prison, or you're going to embarrass the family, or in the case of a teacher or a priest or some person in authority, a perversion of justice, where there is no threat, no intimidation, but these other forms of manipulation. So I hear you, but I just want to put it on the record.
Senator Sheikh.
Thank you, Madam Chair. Honourable Attorney General, if I may just go back to the first part of the amendment where we're removing the evidence filed before the master discloses and substituting the word "there is." Now, I understand what Senator Sobers was saying, which is that the incomplete evidence, so to speak, which is what we're trying to avoid when we have an incomplete hearings, it could come from the magistrate's court or the master's court. It could be one or the same. But my concern in making the change like that is that in the case of the master's court, the sufficiency hearing would anticipate that there is evidence that has been filed before the court that the master is going to make a decision upon. In the case of the magistrate's court, unless it was a committal, you are not going to have filed evidence before the court. So in a case where viva voce evidence was being taken, which does still happen a lot of the time, then this would not encapsulate that. So I would believe that we would still need to have something filed to encapsulate that part of it.
So you're asking about the circumstance of evidence filed as opposed to evidence in the matter, because the viva voce evidence would be part of the record. But I didn't consider that it is just the evidence filed. Is it your suggestion that we ought to capture a broader circumstance of the evidence discloses? In other words, then, more than that which is filed?
Well, in the case of the viva voce evidence, if you have had only one witness, for example, in a situation like that, to say there is evidence is going to be putting a restrictive tone on it. The only way the director is going to be able to go further is to go to the evidence that would have been in his possession, but that would not have been led before the court. So evidence disclosed, it might be another way to put it. But there is, without contemplating that, doesn't encapsulate it, in my humble view.
Taken from 2012, right? Madam Chair, just permit me a moment to confer with the CPC. Madam Chair, I thank the Honourable Senator for a very sharp question. The arguments coming back at me from our technocratic team, the CPC, is that we ought to put ourselves in the position of appreciating that it's the DPP making a decision, and that the DPP ought to make a decision based upon the matter which he properly has. So he's not in the shoes of the magistrate who has heard evidence or evidence that's before him, viva voce evidence recorded in a judicial process. What the DPP would properly have is material that is filed, because it would have been disclosed to him, or he would have originated the information and disclosed it himself. So CPC's caution to us is, place yourselves in the shoes of the DPP, recognize that it's the DPP exercising the discretion, make sure that the exercise of his discretion is narrow upon material which he ought to have properly, and not things which he's making a decision on which may be speculative, particularly with recent events of judicial review, which are yet to be clarified. I think if we went a little bit broader, we might be opening that box just a little bit too much without having settled the law a little bit. I think it's a very sharp observation. I catch the mischief that you're looking at. I take the caution of the CPC, unless, of course, honourable senators have a different view in the round.
Senator Richards?
Thank you, Madam Chair. Through you. Just to go back to the point raised for clarity that Senator Vieira made, and through the intervention of Senator Choate in Part B, the penultimate and final lines. And I know you indicated that the DPP has the discretion in this case, but since you included domestic violence, to fully complete the intent, which is very commendable in this case, it's pretty comprehensive. You included domestic violence, which really specifies a particular context of violence. Wouldn't it be even more comprehensive to include other types of violence and or manipulation and manipulation to give the intent of the clause more force, even though, as you indicated just now in response to Senator Vieira, the DPP has the discretion?
Domestic violence is a term which is cast in the Domestic Violence Act, Chapter 4601, if I remember the correct number of the Act. That definition includes a whole host of things: emotional distress, financial abuse, etc. So that domestic violence is really a term of art and a term of law. I think that if we went to condescend to particularizing what domestic violence is, or to take cohorts of it, we would be inviting an ejusdem generis rule, which is to construe the language of the statute in the manner in which words are set alongside, basically. So we would probably be causing ourselves a little bit more harm if we were to take it that way. I think that the phrase domestic violence can capture those different aspects. Of course, we have the Interpretation Act, which allows us to amplify the meaning of certain words and terms as they are used in legislation.
Just my intention was not specifically dealing with, through you, Madam Chair, the issue of the domestic violence situation, but other types of emotional manipulation outside the domestic setting, which can easily be applied here, especially where children are concerned.
Senator Richards, you and I are both members of a particular a joint select committee, Senator Vieira too, where we are having a massive battle with society as to what emotional distress is in the cybercrime law. If we were to introduce that here now, we're entering into the whole New Zealand debate, etc. We're gonna open Pandora's box.
I'm not suggesting, and I know Madam Chair is looking at me with a martial eye, and rightly so, but I'm not suggesting emotional distress, but manipulation is very common where children are concerned.
The problem is determinations of law, where they have to be precise.
Thanks for response.
Senator Hussain?
Madam Chair, just let Senator Sheikh take the point.
So you're yielding to Senator Sheikh?
Yes, I am.
As he
Because
should.
after Senator Sheikh, I'm going to ask the Attorney General, I'm going to move the vote on the particular section.
I'm very
Senator Sheikh?
grateful. Honorable Attorney General, if I may, I understand the point as to, yes, it's in the director's discretion and based on what the evidence is before him. But what I'm trying to understand is, okay, if we were to go back to the Parent Act, subsection 2, which allows the director basically to deal with anything So voluntary bill, so to speak. So no need to go through all of the sufficiency hearing or the PI in that case. What makes this particular piece, this clause, different? I would expect that you're contemplating to deal with these particular issues, one, but two, that there must be some sort of transparency with it, please. So based on that, it's either something is being filed before the court to generate the director's exercise of his power. So based on these documents, I am now exercising my power to facilitate an indictment, having regard to the fact it was incomplete for this reason, and this is the evidence that I'm relying upon. So something to be filed before the court, which would set it apart from subsection 2, because otherwise we could have just added 1 to 4, numerals 1 to 4 in subsection 2. It wouldn't be of any difference, really. So my humble suggestion, Honorable AG, is that there is something that puts that we need to file it within court, what the evidence is to be relied upon.
Sorry, could I just ask a question, Madam Chairman? I don't know, with all the amendments, I might be mixing myself up, but we are looking at the part that deals with the summons to be directed to the accused person. Am I correct in saying that? No?
We're dealing with Clause 5, which amends Section 6 of the Act, where we're allowing the DPP to prefer an indictment and skip a sufficiency hearing.
Right.
6(3) of the Act. Yeah.
So what I wanted to say is, in any event, when an indictment is filed, doesn't the Criminal Procedure Act still kick in? And doesn't the Registrar of the Supreme Court still have the duty in law to provide the depositions, witness statements, and any evidence which may have been taken viva voce to the accused person within
Yes.
a particular period of time?
Yes.
I mean, I know we have enacted so many pieces of legislation that we may very well have abolished that, but I don't remember if that was the case.
We didn't.
If not, then that may assist with Senator Sheikh's observations.
Also, Chair. And I echo Senator Choate, and just to say that we too were looking at that concern that you raised, but I think it may be better dealt with at Clause 10, because this particular Clause 5 really is concerning the remit of the DPP and his discretion.
Yes. So, Madam Chair, if I may answer.
I don't think there's a need. I think Senator Vera and Senator Choate have said, and it's on the record, so I don't think there's a need to respond. I think the
Your
position is
martial
clear.
eye has come into a martial decision.
Yes. So, Honourable Senators, the question is that Clause 5 be amended as circulated by the Attorney General. Those in favour say aye. Aye. Those against say no. The ayes have it. Honourable Senators, the question is that Clause 5 as amended now stand part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it. Clause 5 as amended now stands part of the bill.
Clauses 6 to 9.
The question is that clauses 6 to 9 stand part of the bill. The question is that clauses 6 to 9 now stand part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it. Clauses 6 to 9 now stand part of the bill.
Clause 10.
The question is that clause 10 stand part of the bill. Attorney General, there is an amendment circulated on your behalf, and there is also an amendment circulated by Senator Hussain. So, Senator Hussain, I will ask you to speak about your amendment.
Madam
Your
President,
yeah.
my amendment was born out of the fact that when I read the insertion of subsection 6, it would have read as though that the power of the trial judge was being curtailed by the fact that the evidence would have been admitted as a matter of fact. and I saw the Attorney General's amendment, and it may cover the amendment that I am also seeking. So, Madam President, in these circumstances, having regard to reading the Attorney General's amendment, I will withdraw my amendment.
You will withdraw?
Yes, please.
Okay, so let me just take a note. Attorney General, will you speak to your proposed amendment?
Yes, please. As I propose to further amend it, having had the chance to have a chat with Senator Vera during the recess. Madam Chair, I thank Senator Hussain for withdrawing his proposal. I understood the context in which he was coming at it. Same issue, slightly different course. Madam Chair, we took note of Senator Choate and Senator Hussain's submissions during the course of the debate, and I think that prudence dictates that we adjust the word shall to may to definitely preserve the court's jurisdiction, the court's discretion in admitting evidence. It ought not to be a fait accompli, and certainly not from a legislative perspective. Senator Vera raised with me the fact that depositions taken and exhibits admitted in proceedings appeared to be a narrow category of matters. And he asked us to consider witness statements filed, exhibits admitted in, and other relevant portions of the record. And I've asked CPC to have a look at that, and CPC has crafted an amendment to include those words. I did say that I would fall squarely now upon the experience of Senator Choate. Whilst I have good experience in the civil law, I don't want to even pretend that I could capture the species that Senator Choate would be aware of in her practice as senior counsel. I mean, no disrespect to other criminal practitioners here, Senators Sobers, Sheikh and Hussain, who obviously have experience as well. So the proposal, Madam Chair, is not only that we amend the word shall to may, but that subclause 6, just after the words admitted in, we include the following. So it should read this way, if I were to read it clearly, as subclause 6. Subclause 6 would be depositions taken, comma, depositions taken in, comma, witness statements filed in, comma, exhibits admitted in, comma, and any relevant portion of the record of comma, proceedings instituted prior, and then we continue, may be admissible in evidence at trial of an accused. So, subject to being corrected by Senator Choate in particular, and any others, I wonder if that wording is acceptable. So we're saying more than just depositions taken and exhibits admitted in, broaden the category to depositions taken in, witness statements filed in, exhibits admitted in, and any relevant portion of the record of proceedings.
Senator
Yes,
Choate?
and perhaps I should say, Senator Vera and I had some discussions about it, and the reason I had suggested that we put in this portion of the record part is because, for example, we may need the endorsements at the back of an information to form the basis of a legal application. We may have situations where a witness whose witness statement has been filed has given additional viva voce evidence which forms part of the record. There may be an alibi notice given which also forms part of the record. So I was thinking along the lines of those things when I suggested that that should be included. So I know it sounds like quite a mouthful, but I think it covers everything that we should be thinking about.
We're very happy to promote it, pursuant to the recommendations. Not being a subject matter expert in the criminal proceedings, I am guided by those with better experience, obviously. So, Madam Chair, would you take the amendment as circulated, as further amended in the manner that I have read?
Yes, I just need for you, for our records, to just reread the proposed amendment.
Yes, please. So, Madam Chair, the proposed amendment to subclause 6 of clause 10 is that we will
Depositions taken in, comma, witness statements filed in, comma,
yes,
and the exhibits admitted in, comma, and,
right? So comma, no and. So
Witness statements
filed
filed
in,
in.
comma. So we delete that word and. We go exhibits admitted in, comma. Then and any relevant portion of the record of, comma, proceedings instituted prior to the coming into force of this act may be admissible as evidence at the trial of an accused.
yes,
Yes?
yeah. Honorable Senators, the question is that clause 10 be amended as circulated and further amended to read as follows. Depositions taken in, comma, witness statements filed in, comma, exhibits admitted in, comma, and any relevant portion of the record of, comma, proceedings instituted prior to the coming into force of this act may be admissible as evidence at the trial of an accused.
Yes.
Those in favor say aye.
Aye.
Those against say no. The ayes have it. Honorable Senators, the question is that clause 10, as amended, now stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clause 10, as amended, now stands part of the bill.
Clause 11.
The question is that clause 11 stand part of the bill. Senator Hussain, there is an amendment circulated.
Thank you very much, Madam
Proposed
Chair.
amendment
Yes, I
circulated.
yield to Senator Sobers in order to pilot this particular amendment, please.
Sure. Senator Sobers.
Grateful, Madam Chair. Honorable AG, I know that in terms of your wrapping up, you spoke about section in 32A, 5B, with respect to an agreement between the accused and the prosecution for an available session date. And I know that when we were here in February, I also had an issue with the logistics behind such an option being made available. And I know with respect to the civil realm, it happens all the time, so that you would have situations where matters could even be adjourned or new dates of hearing could be proffered based upon an email being sent to all parties. But because the actors within a criminal situation are different, I suspect that there could be some mischief created with respect to a situation like this. So I was considering whether or not we should just simply delete 5B and just leave it at 5A, that the next available session day as determined by the registrar, full stop.
Madam Chairman, may I
Yes.
respectfully lend my support to that proposal for the simple reason that you have people on bail, people who are remanded on bail. So essentially what you're doing by having this in is you telling somebody who is remanded by a court on bail to appear before a court on a particular date that you can agree out of the court order. And I think that might be a bit dangerous.
Attorney General.
Madam Chair, I welcome the submissions and I ask, if we were to confine 5 to the next available session day as determined by the registrar, I understand that. But if a person is in the circumstance that Senator Choate just gave, you're remanded on bail, your remand is in a different cycle from the day you're supposed to come before the registrar, you're still in the same situation, because the registrar may give you a date and your remand period may be different. The intent behind subclause B was to allow for agreement between accused and prosecution with the involvement of the court, that the court had to be satisfied that that ought to happen. It happens in other jurisdictions, largely where there is prosperity in rules operating and communication and facilities. So we wanted to preserve the legislative ability to do this. Obviously, the bugs will have to be worked out as to how you treat with bail and other issues that come up with it, or compliance with an order in general. Let me not just say bail. There may be other conditions that are attached to it. So we had this recommendation coming from the judiciary itself, and we'd also had recommendations coming from Mrs. Elder as to this particular amendment. I didn't think that it would be something which the registrar would order without reference to the fact that there are other consequential orders that may be affected. But I wonder if it would not be that the appearance before the registrar, as agreed, is itself an order which would vitiate any difficulties that a potential breach of an order may theoretically cause.
Senator Sheikh?
Honorable AG, one other thing to take into consideration. One, I do think it would create some problems with respect to scheduling and so forth. And in any event, the rules does contemplate that these applications can be made. So it may not be something that needed to be legislated. Also, apart from that, because this is something that might be done in the absence of the accused, I think that's also something that we need to consider. Because anything from agreement with defense and prosecution is sometimes viewed with a certain amount of skepticism by the accused. So we prefer for these things to be done in their presence rather than agreeing anything behind their back. So it's a protection as well for the attorneys involved.
Senator Vera?
Thank you. I agree with Senators Choate and Sheikh. I think we're coming now in the wake of the new criminal procedure rules and active criminal case management. I think that renders B otious. In any event, case management would require accused and prosecutor to collaborate and to indicate dates and timetables.
So, Madam Chair, I take the caution. We're having a battle, as I sit as a member of the Rules Committee, having to sign off on the rules that are put to me, where we have very polar positions on the interpretation of law. And it always flows back to, do you have the legislative authority in the parent law to treat with this? We ran into this obstacle in the civil proceedings rules as well, which were originally designed to have case management done by masters as opposed to just by the judge, so that the judge could receive case management from the master. In my view, it's still a very sensible route that ought to be the case. But the Rules Committee back then took years to figure out that process. And they argued over it because they said the primary law didn't provide for it. So, in fact, I'm sitting on rules right now for the period of 1 month as I'm getting advice on which version of the law is in fact correct, because people are quite prepared, and rightly so, to litigate everything under the sun and the moon. So, question is it really osiose insofar as it provides a legislative springboard for agreement between the parties, particularly in light of what Senator Sheikh has just said, which is there may be odium if something like this happens without the presence of the accused. That causes my alarm bells to ring, obviously. But we've already legislated in Act number 20 of 2011 the fact that you can take steps, particularly in remand conditions, in the absence of the accused. It's in the Parent Act. So when we deal with summonses, warrants, remanding, etc., we've legislatively provided for the absence of the accused in those circumstances. So we're not being inconsistent on this occasion, and it is still a court to deal with it. The mischief that we're treating with is I'm having a battle with the Rules Committee side of it, telling me, no, go back to Parliament and amend the law. We're having an active debate right now about whether masters need to be Hinesed, if I could put it that way, for the lawyers in the room. RV Hines to apply for them. Masters are appointed by the JLSE. Their terms and conditions cannot be derogated from. They sit in the court. But if we do masters, what about magistrates? A magistrate in exercising summary jurisdiction under the Copyright Act alone has massive powers, or the Insurance Act, etc. So our law is in a state of flux right now, and we're looking for some assistance from a legislative springboard perspective to at least cure the arguments that can come at us. having the absence of the accused issue, it's an important issue, but we've already legislated for it in this law since 2011.
Yes, Honorable Attorney General, if we may, to use an old-time word, hew back to the original constitutional principles.
Yeah.
Bail is a constitutional right. So the practical difficulties that the Rules Committee may be having, with all due respect, in dealing with the preparation of secondary or proposed legislation ought not to affect our deliberations here. We have an accused person who has a constitutional right to bail, which is derogated from in accordance with the Bail Act, which was passed with a constitutional majority. Senator Sheikh's point about the process, the criminal trial process or the criminal hearing process being embarked upon in the absence of an accused person is a very serious one for attorneys at law who will incur the wrath of clients if the clients are of the view that after having spent 5-6 years in custody awaiting trial, that the attorney has gone and agreed to a date that the client doesn't like. So there is that very powerful aspect of it. In any event, the person in custody on remand ought to be able to have some certainty as to when he is going to come before a court, and that certainty may not be protected if we give this discretion, which is contained in 5B. Now, I see that the registrar, in any event, in the preceding subsection, has the ability to determine the date at the next available session, which is what currently exists. When you committed to stand trial at the magistrate's court, you may be placed on bail or you may be remanded in custody, but you are sent to the next hearing of the criminal sessions. So it continues until you reach the High Court. So it's not that it's non-specific. It is when you get your indictment, you know that you are before the court. So there is a process which tells the person in custody or on remand that this is what you are looking at. I think this B is unnecessary, having regard to what A says. And I also think that it allows for too much mischief and confusion in the process, which ought to be clear. It ought to be easy to understand for lawyers, and it ought to be easy to understand for clients, accused persons, whether they are on bail or on remand. So with all due respect, I urge you to consider the removal of B.
Could I just, so that I have it clear, then the sole mischief left on the plate right now, which is a laudable one, is the protection of the representatives from a client who will recant on opposition and saying, well, I never really told you you could have adjusted this date without my being present. Does that still apply even in the context, I'm going to borrow from the civil law now, where attorneys in filing a consent application actually basically certify that they have their client's instructions or have the client countersign?
Well, as I understand it, sorry, I beg your pardon, and I apologize. No, I think let us stop this analogy with the criminal procedure rules. I think criminal procedure rules have their place, as do the civil procedure rules. I don't think that we can always draw appropriate analogies. I think that when we come to looking at legislation which affect people's liberty and their due process rights, we have to be very careful.
So it is just the issue of consent. Madam Chair, may I?
Attorney General,
Yeah.
yes.
I think that there's a compelling argument put forward for the deletion of the clause, certainly because I would have an obligation to go back and do some more work on it. So I think if we were to err on the side of caution, that Senator Sobers, Sheikh, and Choate have made a compelling case for the deletion of 5B. What we will do on our end is to go back and do some further work from a policy perspective versus factual perspective to see what the real intent of the judiciary was in managing this particular process. So, Madam Chair, I respectfully agree to Senator Sobers' suggestion that 5B be deleted.
Senators, the question is that clause 11 be amended as circulated. Those in favor say aye.
Aye.
Those against say no. The ayes have it. The question is that clause 11 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 11 as amended now stands part of the bill.
New clause 12.
Senator Hussain, I have had a look at your proposed new clause 12. I see that the proposed new clause 12 is dealing with an amendment to section 6 of the Act. Now, this bill has already dealt with section 6 of the Act. You are proposing, I believe, further amendments to section 6 of the Act. But if it therefore does not fall and is not relevant to the subject matter of this particular bill.
If I may, while drafting the amendments, I had a difficulty with whether or not it would have formed an amendment to the bill or whether or not it would have formed a new clause, simply because the AG would have amended 6.3 of the Act at clause 5, I believe. This was going to be an amendment to 6.2, which directly touches and concerns 6.3, because what the amendment is doing is asking for an application to be made at 2, which would have encapsulated the DPP's power under 6.3, which the Attorney General would have amended. So I felt it very, I didn't know if it was proper to have amended the bill itself at clause 5, but rather to substitute it as a new clause in order to touch that same power that the Attorney General amended.
I understand what you are saying, but in the way we deal with it in committee stage is we deal with clauses that are relevant to the bill that is before the committee and before the chamber. Because if, therefore, we were to proceed on that basis, then we can have more and more new clauses coming out, which will be relevant to the Act, but not relevant to the bill that is before us. Yeah? So I, therefore, Senator Hussain, I will not put your proposed new clause 12 for any, I will not put it to the committee because I don't think it is relevant to the bill. Okay?
New clause 13.
Senator Hussain, again, new clause 13 proposes to insert a new section 35. Again, this is completely off of what the bill that is before us has contemplated. And therefore, I have to rule in a similar way, and I won't be putting new clause 13 to the committee either.
Again, simply because of the same reason, and these were some of the issues raised in the debate, hence I would have filed this particular clause just for the record.
Honourable Senators, the question is that the bill as amended be now reported to the Senate. Those in favour say aye. Those against say no. I think the ayes have it. The bill as amended will now be reported to the Senate. Attorney General.
Thank you, Madam Chair. Madam President. Madam President, I wish to report that a bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011, was considered in Committee of the Whole and approved with amendments. I now beg to move that the Senate agree with the committee's report.
Honorable Senators, the question is that this Senate agree with the committee's report on a bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011. Those in favor say aye. Aye. Those against say no. The ayes have it. Attorney General.
Madam President, I beg to move that a bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011, be read a third time and passed.
Honorable Senators, the question is that a bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011, be now read a third time and passed. Those in favor say aye. Aye. Those against say no. The ayes have it.
A bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011.
Honorable Senators, even though it is not yet time, but because I am looking at my martial eye, casting it on several of your faces, we will now suspend the sitting and we will return at 5:45. So we are suspended until 5:45.